This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to explain why only fools fail to read a policy and assume that coverage exists, and why courts, unlike normal people, may never assume that a coverage exists but must only deal in facts. And it should be axiomatic that an umbrella insurance policy does not always follow the primary policy, and it's important that the insured or the insured's representatives actually read the policies they buy. In Grange Insurance Company versus Georgetown Chicken Coop et al., now called Roosters, it had issued two insurance policies for a group of insureds that started with a business owner's policy, a BOP, and a commercial umbrella policy, a CUP. All parties agreed that the BOP provided coverage. It specifically covered liquor liability, and the CUP, for some strange reason, specifically excluded liquor liability. The Court of Appeals of Kentucky on October 20, 2023, resolved the issues between the parties after reading the full umbrella policy and ruled on its language being unambiguous. The lawsuits arose because on the night of January 5, 2019, Joey Lee Bailey was served and consumed alcohol at Roosters in Georgetown, and after leaving Roosters, Bailey went to another place called Horseshoes in Lexington, Kentucky, where Bailey continued to drink. Then, during the early morning hours of January 6, 2019, Bailey was driving the wrong direction on Interstate 75, and his truck hit a vehicle carrying the 5-member Abbas family. All 6 people were killed. The estate sued. Roosters sued for declaratory judgment against their insurer, Grange. Grange then sought a legal determination concerning their insurance coverage under the CUP or umbrella policy. Roosters sought summary judgment, which was granted, and Grange, of course, appealed. Even if a court finds an ambiguity in a policy, courts still may not rewrite the plain language of a policy examined as a whole. The Circuit Court declared an ambiguity and ruled in favor of Roosters. It found that ambiguity and also made a general observation about umbrella policies. The difficulty with the decision of the Circuit Court flowed from the following paragraph in the Circuit Court's conclusions of law. Quote, "There is no purpose for an umbrella policy if not to supplement the underlying policy if exhausted." Close quote. What the Circuit Court ignored was that the purpose is only to supplement underlying policy coverages that the insurer agreed to supplement. The COP was not a follow-form umbrella and had different terms and conditions than the BOP. The primary insurance for Rooster was provided by Grange with the BOP. Liquor liability coverage was provided by an endorsement to the BOP. The parties agreed that liquor liability coverage existed in the BOP. Roosters also purchased the CUP, an umbrella policy with Grange. Umbrella policies are often purchased, but as in real-life thunderstorms, some umbrellas provide more coverage than others. The Court of Appeals noted that your feet may still get wet with the best umbrella. As a general statement, umbrella policies, as one form of excess coverage, follow the primary policy and provide additional coverage. Such policies often provide additional coverage for some claims not in the primary policy. An umbrella is not necessarily a mirror image of the primary policy. In fact, it often is not. An umbrella policy may have its own exclusions. The Court of Appeals stated that it was unable to find authority for the proposition that an umbrella cannot exclude additional coverage for certain claims covered by a primary policy, since they are two separate contracts. That is why the first paragraph of the CUP states, quote, "Various provisions of this policy restrict coverage. Read the entire policy carefully to determine rights, duties, and what is and is not coverage," close quote. The word replace is not technical. And since the umbrella policy replaced the liquor liability coverage, the entire section in the form policy was removed and replaced by the language of the endorsement that eliminated liquor liability coverage without ambiguity. The expectations of the insured do not control. Courts are not in the business of assumptions. Rather, a court must apply facts to the law. Refusing to acknowledge and accept the circuit court's assumptions that an umbrella policy must provide coverage excess over all of the coverages provided by the BOP, the Court of Appeal reversed the trial court. The Court of Appeals directed a declaratory judgment that the CUP does not provide coverage and thus also does not impose a duty under the CUP to defend the claims in this case. In my opinion, whenever an insured or a court assumes facts or coverages exist without applying the actual language of the policy, they must break the word assume into its component parts, and Roosters and the trial court's assumption of coverage made an ass out of the insured and the circuit court. Although few actually read an insurance policy, that is no excuse for any insured who did not pay someone to read it for them if they were unable to do it personally. The Court of Appeal, however, had no choice. It read the policy and it applied it as written and reversed the decision of the trial court. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog and you will receive notice free of charge of every blog posting, usually 5, sometimes 6 a week, and access to the more than 4,600 blog posts. You can also subscribe to the videos on YouTube and rumble.com, and I'd appreciate it if you do, if you click on the like button on YouTube or the thumbs up button on rumble.com. And I'd appreciate it if you subscribe to rumble.com or to the YouTube videos so that you can receive them as they are published daily. And if you wish additional detailed information about insurance, insurance law, insurance claims, and insurance fraud, please, for a very small fee, consider subscribing to my Locals community or my Substack publications. Thank you for your attention.